Hi, folks. It's my pleasure to welcome you to Session 5, Reducing Barriers and Increasing Incentives. I'm KRISTEN Rosati, a partner at the law firm of Coppersmith Brockelman and a past president of the American Health Law Association. I do a lot of work across the country to help put together big data sharing arrangements for research and other various purposes, and I look forward to moderating the first part of this session. So in this first segment, we'll focus on the legal barriers to data sharing, and more precisely, how to reduce those barriers. We thought it would be useful to kick off the discussion with an overview of the legal issues involved in data sharing, which I'll cover. We'll then move to more in-depth discussion of a few focus areas that we thought would be particularly useful for the audience. I'll go ahead and do the introductions to the panel now. First, we'll have Mark Rothstein, Herbert F. Bohl, Chair of Law and Medicine and Founding Director of the Institute for Bioethics, Health Policy and Law at the University of Louisville School of Medicine. Mark will be talking about seeking informed consent for large-scale data sharing, and will focus on some of the especially tricky issues posed in consent for large-scale data sharing. Next, we'll turn to Cora Hahn, Chief Health Data Officer of UC Health at the University of California. Cora has a great deal of experience in data governance at UC, and we'll talk about UC's experience as gatekeeper and cheerleader for data sharing. Finally, we'll hear from Anita Allen, who is the Henry R. Silverman Professor at the University of Pennsylvania Law School. Anita will discuss the evolving ethics of data sharing. All of the speakers' bios are in the materials, which will provide details about their just great level of experience and insight into these issues. We'll do our best to stay within the time allocated to us. And if we're successful, we'll have about 20 minutes of discussion and Q&A with the speakers and participants. And with those introductions, I'll launch into the substance. So in the time we have, this necessarily will be a really bird's eye view of the legal issues involved in data sharing. My goal here is to provide you some context to understand the categories of laws that apply and the complexity of data sharing between legal entities. Let's see, now I have to figure out how to get my slides to forward. Technical difficulties already, heavens. Aha, found it. Excuse me. Okay. Of course, the first set of laws to consider in data sharing are data privacy and security laws. HIPAA is the most obvious set of regulations that apply to data sharing, but there are also federal regulations, as you probably know, that govern substance abuse information, and of course, federal regulations and policies governing research. But state laws are having an increasing significance in this space. And there are a variety of state laws to consider, including consumer privacy laws, state health information confidentiality laws, state licensure requirements, et cetera, which apply to different types of legal entities. And then finally, in international data sharing, we likely have to deal with other countries' laws, including the EU General Data Protection Regulation, or the GDPR. We also have two new kids on the healthcare regulatory block called the Information Blocking Rule and the CMS Interoperability Rule. This is a very interesting development in data sharing because it's a true paradigm shift to presuming that data should be shared. While HIPAA and the other health information privacy laws start from the presumption that you can't share data unless specific rules let you do so, the information blocking rule starts from the opposite presumption. If you are covered by the rule, you have to share data unless you're prohibited by law from sharing the data, or unless you fall within a regulatory safe harbor. The effective date of the information blocking rule was April 5th, just a few weeks ago. And the healthcare industry is still, frankly, confused as heck about how to square up the information blocking rule with HIPAA and other health information privacy laws. But it's an important development that will modify how we approach data sharing in the healthcare industry. And then you have a host of other legal issues that come up in data sharing arrangements. First, who owns the data? In my opinion, the concept of data ownership ends up not being a very useful one because there are very few laws that expressly state who owns healthcare data. Instead, it really comes down to who has the right to do what with the data. And that has to do with what laws apply, the institutional policies related to data sharing, which Cora will cover, and third-party contractual restrictions on data use. We won't have time to discuss the other legal issues that come up in data sharing, including antitrust compliance, anti-kickback laws, and legal requirements related to downstream use for particular purposes. The topic I'd like to spend just a few minutes on is de-identification of data, because that's really the workhorse of many data sharing arrangements. We have a real challenge coming on this issue because the standards for de-identification are actually evolving. As you likely know, the starting point for de-identification are the HIPAA standards, and there are two methods of de-identifying protected health information: the safe harbor method, in which all HIPAA identifiers are removed, and the expert determination method, under which a qualified statistician determines that there's a very small risk that an anticipated recipient of the data could identify individuals in the data set. This graphic comes from the Office for Civil Rights' excellent guidance on de-identification, which I really commend for your reading. Oh, I'm having a hard time getting it to forward again. Here we go. Where the HIPAA standard gets tricky is determining whether genetic information can be de-identified. Many people think, of course, genetic information is identifiable because it's what makes us unique compared to every other person. But that's only true if the recipient has what's called a population register that matches genetic information with someone's identity. So let me walk you through my reasoning regarding the HIPAA analysis. Genetic information is indeed health information under HIPAA. However, it's not protected health information under HIPAA unless it's individually identifiable. And information is not individually identifiable unless it identifies the individual directly, or if there's a reasonable basis to believe the information can be used to identify the individual. The OCR, the Office for Civil Rights, the agency that enforces HIPAA, has concluded that not all genetic information is individually identifiable, but unfortunately hasn't provided specific guidance on when it is individually identifiable. I think the most common legal interpretation, and one I take, is that genetic data is not itself individually identifiable unless it's accompanied by HIPAA identifiers, or unless it's released to a recipient that you know has a population register that can link some of the genetic information to a person's identity, such as a genealogy database. However, that standard likely will evolve because of the increasing amount of genetic information available about individuals, both in genealogy data and also increasingly in medical records. In other words, more people in the healthcare industry will be able to match up genetic information with someone's identity. Moreover, the common rule is evolving, including in its treatment of what information is identifiable. For the time being, HIPAA de-identified information is still treated as non-human subject research under the common rule, unless information is collected through interaction or intervention with individuals for the particular research. But what's important to watch for is that HHS is required under the common rule to publish a guidance document on whether there are certain technologies or techniques that will necessarily produce identifiable information, even if the information is not accompanied by traditional identifiers. Whole genome sequencing will be first on the list for evaluation, no doubt. So watch that development. But what this means is that under the common rule, some genetic information without identifiers might be in the future, perhaps in the near future, be treated as identifiable information after this HHS guidance comes out. This would be a major change in research regulation and could represent a big disconnect between HIPAA and the common rule. And as I mentioned earlier, state laws are increasingly important in evaluating what data and de-identified or genetic information can be shared. Some genetic information laws restrict the sharing of de-identified genetic information. Also, state consumer laws are on the march. It all started with the California Consumer Privacy Act, on which many other state privacy laws are being modeled. Thankfully, the CCPA recently was amended to adopt HIPAA's standard for de-identification, so we don't presently have a disconnect in how to de-identify data. But be on the lookout for states that don't use HIPAA standards, but instead look to the GDPR standard for de-identification, which is a lot more ambiguous. What's really different about GDPR versus HIPAA and other United States laws is that there is no de-identification safe harbor to follow. Under GDPR, data is not personal data if it is anonymized, in that it can't be used by any person to identify a data subject. In other words, no links or coding. Data that is coded so that the recipient can't identify a person, but the data source can link the data is not anonymized. It's pseudonymized under the GDPR and still protected by the GDPR. Now, with that very quick spin through the legal issues governing large-scale data sharing, I'm going to pass the virtual baton to Mark Rothstein. Thank you.